Hi, my name is Vlad Genshu, and I am a civil litigation jury trial attorney here in Southern California. I try personal injury litigation trials in front of juries. I've tried a couple bench trials. I have tried up to now 17 civil jury trials, 14 of which went all the way to a civil jury verdict. I do the vast majority of my trials all by myself. I don't have any second chair. I have never second chaired a jury trial. I want to talk to you about today the concept of a disputed liability personal injury case. Let's just say it's a car crash. I want to talk to you today about not falling into a fallacy. Okay? If you have a case that is a disputed liability case and it is word v. word, meaning you don't have any witnesses, there's no police report, law enforcement did not arrive at the scene, and no police report was taken. You don't have any independent witnesses, meaning there might be people in the defendant's car, the civil defendant's car, the person you're suing. There might be people in your car, but presuming those people are family members, nobody's really going to call those people independent. So you got to look at it. It's basically word v. word. Everybody's going to take what everything is being said with a grain of salt. The jury's going to do that because they're going to think that obviously everybody's got a bias when they come, to discuss and prove their own case. That's just common sense. Everybody's got that. Everybody's got their own perspective. If you're suing or you're defending, you're going to see it through, the glasses that shade your eyes and that give you a perspective on life and a perspective on the crash. You're going to remember it your way. And we know that because you have witnesses, even independent witnesses to a scene, to a crash, to a slip and fall, trip and fall, dog bite, in a criminal case, to a crime, and they remember things totally different than the way other people remembered it. It's just memories fade over time. If you don't have basically law enforcement there or a video or something like that, and you got a word v. word, and you got an intersection dispute, a light dispute, a left turn dispute, you want to make sure that you can prove your client's case. I want to talk about that for a second. You might fall into the fallacy that you can prove your case by disproving the defense's defense. And I've tried, 17 civil jury trials, 14 of which went to verdict. Do not rely on the idea, the concept that because what the defendant is saying, what he or she is saying, the person who's being sued, that what they are saying is so outrageous, it just doesn't make any sense. Or it's the good old-fashioned, I don't remember, I don't know, I don't remember, I don't know, that boom, you just proved your case. That's not the case. It might not, it might sometimes help you and assist you, but you're not going to win by basically saying, see, the defendant can't prove their defense. They don't have to basically disprove your case. Just by disproving a negative does not mean you win. Now, they have to prove affirmative defenses. That's what the law says. The jury might not get that at all. But just because they can't, you can disprove what they're saying and they're on the defense, that doesn't mean that you win. Especially when you have a disputed liability impact, right? If somebody is saying, hey, this person failed to yield, that's what the defense is saying. There's a code on that, on point. You better have somebody, you better have your client, you better have a witness who says, yeah, you know what, I saw that. Because a lot of people are going to say, we need to have somebody prove that. You can prove a rear-end car crash pretty simply. You take a look at the property damage, and you're proving that also objectively. Take a look at the property damage. Which car was ahead? Which car was behind? Are they going to admit to it? You need to prove your case. Just because the other side, in their deposition, the defendant, totally basically said they forgot everything, and the only thing they said is, I'm not at fault because I'm not at fault, that doesn't mean you're going to win your case. The jury might still say, okay, well, we found that incredible, what the defendant said, that they didn't remember anything, but did you actually prove your case? And it's very, it appears at first blush to be enough to say, well, who could possibly forget everything in a car crash? And you could drill down on that the defense forgot everything, but that doesn't mean that your client actually got on the stand and proved why the other side was at fault. If the other side basically says, I don't remember, but I just wasn't at fault. And, the problem with that situation is you can't forget, as a plaintiff's attorney in a civil case, that you have the burden of proof. You have the burden of proof. You are asking for compensation for your client's past medical bills, past pain and suffering, general damages, special damages, loss of wages, lost earning capacity, possibly exemplary and punitive damages. You need to prove to the jury that your client deserves that, which means that the other side is at fault. Okay? And if you think that you are going to front load your case with bad facts of how the defendant doesn't remember anything, and your theory on liability is not cutting it, it's just not getting to it, because either the cross-examination of the defense works or your theory is not straight enough, meaning it's not just straightforward enough. You need to think about this. You're going in front of a jury and you're asking them for money based upon negligence that somebody else caused. It needs to be the closest thing you can get to an arrow out of your quiver. You pull that arrow and it's got to go straight to the target. The defendant, if they pull their arrow out and it, blows up in front of them where it just zigzags, doesn't even go, that's great for you. But remember, the defendant doesn't have to do anything. They don't. They could sit down, and many times they do. They don't call any witnesses. They might redirect their client on 776, and you're sitting there and you're saying to yourself, I won. Jeez, they didn't call anybody. They didn't call a doctor. They didn't call an accident recon. We're good. We're in the clear. That's not always the case, because if your theory on liability does not make sense to the jury, either the way you presented it in an opening statement, or the way your client presented it, or the way the questions you asked, or the jury doesn't get it, maybe you should have done some kind of an accident reconstruction. Maybe you should have hired that expert. Maybe you shouldn't have. Maybe it didn't make a difference one way or in the world. But you need to ask yourself, if you have a disputed liability case, okay, the defendant's going to get up there and they're going to say, I didn't cause it. Okay? Your client needs to prove that they did. Okay? Don't rely on the fact that what the defendant is saying makes no sense. That will only get you so far. You need to prove your case. The defense attorney is going to go up there in closing argument, and they're going to go up there in opening statement, and they're going to say, I don't have the burden. I don't have the burden. This is not for me to prove. They're suing my client. That's what they're going to say. And they're going to say it again in closing argument. And they're going to match it with, by the way, I don't get to get up here again. The plaintiff does. Okay? You know why? Because they have the burden of proof. And that's why they get a second bite of the apple through their rebuttal argument. And I don't, as the defense counsel. And they haven't proved their case. And here's why. They're going to go back. Maybe they're going to have in their PowerPoint exactly what your client said on direct examination or cross-examination or both, or in deposition, and they're going to blow it up in front of the PowerPoint. And that's something that you need to consider, because that is going to happen to your plaintiff, to your client, if you're the plaintiff's lawyer. Your client, you're going to have the issue of your client's words, your client's actions, the defendant's words, and the defendant's actions. Unless you get the defendant up there on the stand to say, I caused it, or I was speeding, something that can point to them being at fault. In my opinion, based upon trying cases, just because the defendant says, I don't remember and I don't recall, does not mean that you can, in effect, take that and substitute it for a clear-cut, strong presentation on why your client's not at fault and why they're at fault. They don't have to prove their case. I think it costs them a lot of credibility points. I think it puts a lot of questions in the jury's mind. But I think the idea that you can basically say they're not mounting a real defense, this is not right. It doesn't make sense. They can't remember anything. They're wasting your time. And then use that kind of like extra credit points to fill in the holes in your, back pattern. I don't think it'll work. I haven't seen it work. You need to ask yourself when you get in front of that jury, what's going on here, and are they going to be able to figure it out? You can't prove your case, in my opinion. You can't prove a plaintiff's case by just disproving a defendant's case. Because if you think you can do that, again, it flies in the face of what the defense attorney will go up there and say, which is, I don't have to prove anything. They have the burden of proof. I can sit down. All I have to do is cross-examine their case. Legally, that's true. Okay? And you need to consider that, because if your injuries are great, client's injuries are great, I say that always that tragically, personal injury cases are personal and they're an injury. They're personal to the client, and the injuries are personal to that client. It's a personal injury case. The worse the injuries are in terms of the actual value of the case, in terms of the presentation of the case, it is easier to present. It's worse for the client in terms of that, a catastrophic case is the worst for the client. But even if you have a catastrophic case, even if you have a big, if you will, injury case, the jury has to look at the special verdict form, the way the special verdict, the questions that they get, the way they're put in order. The first question, if it's a disputed liability case, it's on negligence. Okay, they don't get to flip it. They don't get to turn it to page 2 and say, ooh, we really feel for this person. Let's give them some compensation. Then go back to the first question and check. Yes, that's not the way it works. That's not the law. The way it works is the defendant, insert name, negligent? Was the defendant negligent? If the answer is no, you're done. They're done. You as a plaintiff are done. Please sign and date the special verdict. Presiding juror. That's it. They don't go to the next questions. They look at it in that order. The law says that, right? So they can't go and say, geez, this is a really catastrophic case. We feel for this person. Let's give them X amount of money, and then let's put some comparative negligence on it, and then go back to question 1 and say the defendant was negligent. No, that's not the law. That's not what will happen. Do not hope for that. That is wrong. You deserve to lose. What will happen is you will get defensed, meaning the defendant will get a defense verdict, a no on question 1 of negligence. You need to prove your case. You cannot sit there and hope that because the deposition you took of that defendant was so great that they knew nothing. They remembered nothing. They were basically a blank slate. It's like taking a redacting marker because they remembered nothing. Or that whiteout tape. They remembered nothing. That's not going to win your case if your client cannot prove his or her liability theory. It might get you credibility points in the negative, but you need to prove your positive. Okay? And you need to remember that when you try your jury trial. It is still fundamentally your burden of proof. It's not the defendant's burden of proof. Good luck in your next jury trial. Wish you all the best.